first explain a bit the title of my talk, which you find on the program, but which you will not understand without some explanation. It has three parts, the title, as every good German story has three dramatic parts. First, conflicts or constitutionalism. It's constitutionalism, and it is emerging from the European Union, but it is on conflicts. And this is basically what European lawyers don't appreciate. I say that the task of the Union is to deal with conflict constellations and not necessarily to uniform anything and everything. The second is the subtitle, you know, Societal Constitutionalism. I came with an honest effort to find links and to explore the diversity and the commonality of our projects. And to a certain degree, I do that, but I also failed to a certain degree, and this is not your fault, but the fault of my project, of course. And then the third one, power of technicity. This is my observation on what is happening today in Europe, but I am afraid it might happen also at the international level, and then it is a threat to both of our projects, and I could call it or translate it into authoritarian governance or something like that. Technicity is a term out of the Schmidtian debate, as you will see. Now, what I do, I proceed in three steps. I will first do a restatement of what I call conflicts or constitutionalism. I will then proceed to explain why my project is in a crisis, and I will therefore have to talk a bit about the crisis and the power of technicity, and I only will then turn to the international scene, the globe. Now, first, conflicts or constitutionalism. I call it a melancholic restatement because I've written it down often enough, but it is now in another context. Now, what is the core? Two assumptions, very easy, and I think also a principle acceptable to many. And this is the talk about the democracy deficits of nation states. My claim is that European law is legitimate as insofar and because it can compensate democracy deficits of nation state. That's the first normative core of it. And that is important because the talk about the democracy deficit is on the wrong topics, I would say. I would say it should become a talk about the democracy deficits of national governments. The second core assumption is on the eroding power or the eroding potential of nation state to cope autonomously with the concerns of their citizens. European law has the vocation, that's its second dimension, organized, cooperative problem solving. Then, as third vocation of European law and potential, it should ensure that resort to expertise and management capacities of non-governmental organizations and the establishment of governance arrangements deserve recognition. It has to supervise these relationships, and it can do that. These are three functions, and I call this the three dimensions of European conflicts law, and I will try to explain each dimension in a couple of words, but it is indeed also in the paper, and there more explicitly and more exhaustively. Now, what is particularly interesting is not what I have always defended, but where I see the project in difficulties. And one is indeed that the conflict constellations we observe in Europe are indeed getting ever more complex. That is, we observe not just jurisdictional conflicts, but we observe the instrumentalization of European law by national actors to accomplish changes in their governance systems, or to take the European court to accomplish something in other jurisdictions. I could now point to a couple of examples. Take my favorite examples, Viking and Laval, but take the classics like the beer case, and these cases are all about conflicts within Germany. This one, beer and Castille de Dijon. And European law is used to turn the arrangements around. Now, this is interesting, but I don't think this is my toughest problem. The toughest problem is number two, namely the argument that European law has vocation to correct the nation-state failures. What are nation-state failures? Nation-states cannot take into account the interests and concerns of those who are affected by their decisions. And this is why their decisions do have external effect on other citizens, and European law should ensure that we are taking them into account. Berücksichtigungspflicht, as Joerges just said. Now, the problem with that is, of course, that this has its limits. And I cite now from my most famous PhD student ever, Miguel Barreras-Maduro, a piece he has recently written on the financial crisis, and he says, European integration, together with globalization, generates deep interdependencies between national policies, right? Decisions taken by states can have a profound effect on the other state, generating democratic claims from the latter to have a voice in the former state decisions, right? The crisis also has its origin in democratic malfunctions, the unsound financial policies of same states. Some states impose negative externalities on the others. He talks about Greece here. This was possible because the former were able to decide without taking into account the interests of the latter. Here he's wrong, because what we observe here is certainly external effects, but also compensation of these external effects, not by European law proper, but by European regulatory mechanisms, to which I will turn later. Okay, but you see, at least the idea is that you can legitimate European law to a large degree as a mechanism to compensate for nation-state failures. Second one, constitutionalizing cooperation. We have just heard in Joerges Berman's presentation a deliberation on how these people in international conflicts should interact if several jurisdictions are affected or are interested in playing a role in the solution of a problem. This European law has institutionalized, actually. And I call this, especially in the regulatory politics, has been institutionalized, the second dimension of conflicts law. And I have a darling institution, comitology, opaque and sinister, and much discredited, but in principle, a very good invention, namely a mechanism where the actors from different jurisdictions get together and, as I argue, deliberate. They deliberate and they find a solution to a problem which is acceptable to all concerned. This is the regulative idea. I call this deliberative supranationalism as opposed to orthodox supranationalism. But now the problem is also with this second dimension that it is getting into trouble for reasons which are difficult to decipher, but I would say one important reason is simply the amount of decision-making Europe has taken on board. This is so massive that new constraints are coming up, constraints in time, in routine, and what we observe is, instead of comitology, the establishment of ever more agencies, and within the agencies, the turn to scientific, to science, so-called sound science, rather than arguing and deliberation. Now, this I call agentification, and I think it is a form of democratic rule. I could at the same time give you more examples also from traditional comitology fields. My favorite example would be GMO authorization, where you can observe how the European authorities operate, and you see again a very interesting phenomenon, a term, a flight away from the law. It is informal, but it is hierarchical, and it's informal, but it's very strong. We see the same in competition law, one of the really traditional fields of European law. Now, okay, I say this as an assertion. It is this what I call with autocratic or authoritarian governments. The third, charming hybrids. My favorite in all debates on European law, or all debates on non-hierarchical governance, is standardization. And the really fascinating thesis, one really fascinating supervised in France, was by Schreber, and he has done a marvelous analysis of the mechanisms of European standardization and international standardization, showing in detail something what you have done today, to a certain degree, not 8 years, it's not 8 years, it's 8 weeks, but okay, doing in very detailed analysis how these operations operate and why they deserve recognition, what they're doing, and how they are, and that is important, linked to the legal systems, to European competition law, to tort law, to all sorts of things, and how these interactions between hard law and self-governance on the whole form a good arrangement. Now, on the 28th of March, General Advocate Tristan, I don't know how to pronounce that, has handed down an opinion, has published an opinion, in which he suddenly says these organizations engaged in standardization policy or accreditation policy, what we had today, should be subject to the economic freedoms. This is fine at the first moment because we are all subject to the freedoms of the treaty, but she adds the whole bunch of the Procrassus bit of the Cassis doctrines. That is, whatever these standardization organizations do has to be in compliance with the objectives of the treaty and the objectives as they are recognized in the jurisprudence of the court. This is, in that particular case, not yet decided, but the case is interesting because it concerned the lifetime of a pipeline. Now, you can say that's ridiculous, but the lifetime of a pipeline is something you can think about, and the accreditation offices try to stimulate long-term pipelines, long lifetime, right? And the Advocate General explains this is very doubtful because this is not for the health of consumers. So it is the problem, what kind of objectives may these people pursue? And if European law intervenes with its categories here, we are in trouble. So all of my 3 dimensions of European law are in a sort of problem. I observe this and I'm concerned, and I'm asking what is going on. Now this is what is going on, is now in the second section of my talk, and I try to be brief. Now we all know we are in a crisis. I read in the Common Market Law, 80 pages, at least one issue on this crisis, and I read it really, I promise it. I can say I understand it all. But I also try to understand in a more abstract, theoretical level. Yeah, now I'd be very abstract, but it is tough. Okay. This is Schmidt, Karl Schmidt. He's right. So I start. I have these 2 German heroes, Jürgen Habermas and Karl Schmidt. They observe the Union as it is now, one from its grave, one still alive. Habermas first. The crisis, he writes one manifesto after the other. The man is really concerned and angry, and for good reasons. Habermas, the angry citizen, that is quite something. You see it all over Europe in all languages. Habermas, the angry citizen, is supported or seeks support in Habermas, the political theorist. The last essay on the state of the European Union, I think it's now available in English, is indeed, again, a reflection on what he has written so far on European constitutionalism, and it is the old Habermas recycled a bit. What he says now is indeed a very elegant construction. He tries to combine national citizenship with European citizenship without creating a European statehood or federation, and with seeking to provide a basis for European solidarity. Okay, I think that is an honest effort. I don't fully believe in it, but who believes in anything these days? Habermas is Habermas, and he really has developed his theory even further. His harsh critique also is hitting a mark, the Habermas citizen. The imperatives of the markets, I say from one of his many papers, have being transferred to the imperatives of the markets are indeed being transferred to national markets with threats of sanctions and pressures on disempowered national parliaments to enforce non-transparent and informal agreements. And then he goes on with anger and insists that Europe now has to take a decision. Europe has to take a decision. A decision. Has done this. I think that is really huge. okay, he's a bit close. I mean, how can we take a decision? We would like to. And his decision, of course, he calls it aggressive democratization. Yes, okay, that looks nice, but he doesn't tell us how this decision is submitted to us and what we do. So this is why I turn to this other guy, Carl Schmitt. And he is, of course, long dead and can be glad, although we must admit that he has written fantastic things. I mean, this is, with all, you can be a bad guy and write intelligent articles. Okay, I have three elements of the theory, which I happen to know before this crisis began, and this is why I recall them. And the first one is his theory of the so-called Großraum. The Großraum theory was first presented in the keynote in '39, before the war, shortly before the war, where in Kiel, of all places, of course. Those who know Kiel. Anyway, this was in Kiel, and he explained why the traditional Jus Publicum Europaeum is outdated, and the arguments are quite interesting. He says what is indeed governing in Europe, or why the states are no longer able to organize the European space in an adequate way. What is instead dominating is the interdependence in a Großraum economy. We have one economy, and what is also important, we are turning from traditional governance to technicity, we call that. And technology-driven developments have priority, and this interdependence of the economy plus turn to technicity is dominating Europe. It cannot be captured through traditional international law. Second element, he wrote an interesting article in '36 on delegation. The man doesn't know the Biroli doctrine, but he knows, he observes already in the 30s what is going on in all constitutional democracies. I think he leaves out the United States, but he has France, UK, Italy, I think also. What he observes is a turn from legislative power to the executive. And at the end of the analysis, he says even that will make it, who is taking over in legislation is government. Governmental legislation is a thing of the future. Governmental activities rather than parliaments. He was always anti-parliamentarian. The second element. The third one is a bit comforting because he has also a theory of dictatorship. This theory was developed in the 20s already, and his theory was that Weimar is running into crisis. Weimar is in crisis, was in crisis, and he turned in a book which is remarkable on Die Diktatur from 21. He explores the history of dictatorships, and he ends with commissarial dictatorship as one form where the Reichspräsident, the German Reichspräsident, should take power and organize the return to normal conditions. Now, before the return to normal conditions, you have also to, okay, as I first, this third element I would be very careful with, because if we try to update what you upload, what he said, we must say that we don't have this kind of dictatorship now. We have a mixture. We have co-management of the European economy by executives, the Commission, governments, national. It is a compound of actors and not just one. That is a comforting message. However, what we have is the situation to which this kind of dictatorship responds, and this is the state of exception. We are in a state of exception because we cannot live with the rules which are given to us. That is an observation first made by nobody less than Ernst Wolfgang Böckenförde, formerly a judge of the Bundesverfassungsgericht, and a very famous one, also of course a disciple of Carl Schmitt. He appreciates Carl Schmitt very much, but it is an innocent, so to speak, relationship. What he says, Böckenförde, is, and what he observes already 2 years ago, that Europe is moving in a state of exception. And Böckenförde is not by no means saying complacent with that. He says this is for now of the situation and how do we get out of this is his concern. I make an interim conclusion. Why did I hope that the European example of three-dimensional conflict law could be great for the rest of the world? Because everybody, not everybody, but many people thought Europe densely integrated, producing ever more institutional innovations, could provide an example for the world, or could be an example for the world. Habermas has preached that all the time, and Europe is, so to speak, going ahead, and the rest will follow with Welt Innenpolitik and so on. What I observe now is that the European example is becoming less attractive, and what my project is still alive, so this is not to say I have opted for conflicts, the solution of conflicts, not for uniformity. I have not had this idea that Europe should become a powerful new Großraum in the world. No, this is not it. But I opted for this idea that you could, through coordinated problem-solving, set examples for the rest of the world. And this is now, as I've said, at risk. And what we observe is instead a turn to technocratic governance, and in this extreme case of the financial crisis, to not commissarial dictatorship, but to the sort of management of the economy by strong political rule. And this is something which is not foreseen, right? Okay, it is at any rate something we have. I'm not saying it is successful by no means, but it is the powerful move. Now, what is now left of conflict law on constitutionalism as a message for the globe? I do think, first of all, that indeed there are in all three dimensions elements where the rest of the world could learn. I think especially of this idea that our national jurisdictions produce all the time external effects. I would say, well, in your paper, I see them all the time, and this is why I see also why there is a reason to become pluralistic, so to speak, or to respect the other, or to take into account what the other said, and to strive for a compensation of our external effects. The second one, to understand that regulation is a different type. My pluralism is much more, is not just a plural, also pluralism, but I do think that traditional law, regulation, and governance arrangements are three different types of orders, and that this differentiation helps us to understand what can be done at the international level. Now I go in the paper through these three things, and I say, well, what the limits are, and I discuss a bit the difference between cooperative constitutionalization in Europe and global administrative law, and so on. But I have, in terms of 10 minutes, I can say something about what is law and what I constitute. 3 minutes, no. my watch says a bit more. Okay, but you are the boss, the master of the time, usually we have from yesterday. Anyway, what is law? And here I'm a bit traditional, I must say. And I have very early on, I think, one of the few people who have read in 71 what Luhmann has written on cognitive opening of the law. And I have followed this as far as I could. But on the whole, and at the end of the day, I appreciate really good old law. And I believe that this necessity to take decision, to state what is right and wrong, is not always. I point here simply to the writing of Koskiniemi. I don't claim that Koskiniemi is a Habermasian, but I do believe in an article by Klaus Günther where he talks about the global code, the global universal legal code, and develops this idea that communication within the legal code will always arrive at, or will strive for, principles that will help us to decide our conflicts under a legal regime. Now, I'm saying the legal regime that comes at all under consideration is conflict law. Conflict law is the only possible form of transnational constitution. Okay, this is one thing you have to digest, and I have 2 minutes to explain now what I find with constitutionalism. And I would simply say, follow Gunther's 3 categories in the debate with, I think it was in University of Tilburg, where he formed 3 groups of constitutionalists: the people, the non-believers like Grimm and was number 2, Lachlan, and then the believers or the hopeful Habermas, Anne Peters, and then societal constitutionalism. Where would conflicts law, constitutionalism reside? I am not so sure, but I nevertheless think that it is the important, or the message I would have is that it is not conceivable to get beyond or to form some unity, some substantive unity at the universal system, that we can, with the help of conflicts law, design a couple of responses. I don't believe that they need to form then a uniform body. We may distill some good principle. I have taken some notes out of your writing, Paul. But at the same time, I also believe that in order to live up to the promises of constitutionalism, we also have to care about the substance of problems that we can accomplish. And this is why I very much believe in studies of years, or even more so because of older and longer, people who try to show how these transnational arrangements really deserve recognition, how they constitutionalize, and what is their normative credential. Now, these kind of studies can only be selected, I must say, and I would say, okay, this is the situation we are living in, so I don't deliver the theory, but it's in a way a very pragmatic response. If we want to keep up the idea of the rule of law as one which constrains and legitimizes governance, then we have to be modest at the international level. If we also want to live up to the constitutionalist promise that constitutionalization is not just about building hierarchies, but is also about organizing responses to the concern of citizens, then we have to be very careful in our acceptance of transnational governance. What I'm afraid of is what actually Koskenniemi and others also see at the horizon, namely turn to a sort of empty authoritarian governance, technicity, Schmidt would have called it. The term in Koskenniemi is, I don't know, it doesn't matter. It is at any rate the observation that governance structures are established everywhere, and the claim that these governance structures are maybe efficient, but they are not normatively justifiable. This is a query, but I would say this is not a general belief. It is something that one has to explore in separate case studies. Thank you.
We have a little time for questions, and perhaps if we could just ask the question and not a follow-up, so that there can be more people involved in the conversation, that might be helpful. Paul?
So let me ask you about the challenges to the European project posed by the financial crisis. And I wonder how deep the challenge actually is. It feels very deep, I understand. But if you took seriously your idea of the way governance should work, then it seems to me that all that has happened in some sense is that the combination of the technocrats, the European Central Bank, and one set of political actors, namely the German government, has taken a position that has not sufficiently taken into account the, in this case probably, need for growth-oriented policies throughout the struggling countries of Europe. And that had they done so, or if they still do so, that would be a mechanism of shared governance and consultation and so forth that could actually still be successful, and that it's really only a question of a particular economic choice, not a challenge to the form of governmental decision-making.
Now, I do believe that the crisis is much deeper, because the problem is that we have created, after '92, an institutional framework headed by the European Central Bank, which constrains the political or the economic policy making potential we have. And this kind of regime, and this is why we are in a state of exception, is, so to speak, we cannot comply with it. It would ruin us even more. So we step out of it. But the problem of Europe is what I would call the political failure, or the problem with the political Europe, that the European Union is by now apparently unable to transform its regime through the mechanisms the treaties would require, namely through a renovation or a reform. Nobody tries even to, because people are afraid of referenda, they're afraid of anti-European feelings and so on. What happens instead is indeed what you say, and it is not, I would repeat that, it's not commissarial dictatorship by Frau Merkel or somebody, or the Commission, but it is co-management indeed by many actors. However, it's co-management outside the legal regimes in place. So you can say, no, they do international treaties. We are living in a European Union, but some governments get together and form another regime and implement that. I find that deeply problematic, and it's also one where they do not pay too much attention to the dedication or the commitment of Europe to democracy, rule of law, and all these kind of things. So now, if this co-management would be successful, we would be quiet and say, aha, it is a return now to a state, a normal state. But so the European crisis has these many dimensions, and I do not see for now a good way out of it.
Larry? And then Chris.
Thank you so much. You have both elated me and depressed me. And so I have a question out of yeah. Well, it's not. Well, that's actually my question. And so I'm wondering, as you talk, I'm wondering whether you're far too optimistic. I wonder whether indeed what you describe should not be viewed in the past tense, that technicity is not a problem that is creeping and that may require solution, but that indeed we are deep in technicity now. But that the solution, what globalization has done, is provide a solution to state technicity as more technicity, as global technicity. And so now you have augmented my depression, because I've now combined it with Moritz and Jane, and I ask myself, if you're right, and the world has been reduced to technicity, to the management of things through scientism and through the hiding of normative assumptions in these kinds of things, doesn't globalization indeed represent a larger form of what Carl Schmitt had seen as state technicity, global technicity in the private sphere, everything from product certification to the to standard-setting bodies, and that indeed our problem is not one of finding some. I'm Latin, so I will think of the overdressed general on a horse to come and lead us through I'll mix my metaphors, through democratic dictatorship to some paradise. But indeed, where this person is going to march us to is to a more uniformly technicity-driven global culture.
Yeah, that's pretty much Koskiniemi too, I think. Managerialism is this term I just looked at. Well, you see, what I think actually is, so to speak, the hope I do have, is the diversity of the globe. Europe has a lot of political power, And this kind of power which is used now, and the living with this project of ever more Europe and ever stronger Europe is very much on the minds of people. Economic governance is the answer to the failure of the Constitutional Treaty and the crisis of the euro. Now, this is indeed something which is not conceivable at international level. International level exerts its own pressures and so on, but I think what is so particularly worrying about Europe right now is that the project lives on. Dedicated people, I mean, I have all my life admired Habermas. I mean, what does he vote for? A decision for a stronger Europe. And how this could be reconcilable with democratic credentials and democratic governance is nobody explains to us. And this is something, okay, this is not at stake, it's globe. And this is what I'm saying, the European example can tell the debate on global constitutionalism a deal of pragmatic self-confidence, rather live with less political ambitions and lower. This would also be my answer to the European crisis, to say, why shouldn't we in Europe rely on what we have experienced, namely in many fields, a potential to cooperate without hierarchy and to interact on the basis of deliberation. It did work, it was not necessary to step it up all the time. And the risk of being too ambitious is indeed, okay, this is okay, we are not in agreement with everything of globalization probably, but these little islands which may be there and the constant threat that it will be overturned in a couple of months and it will have to adapt and change is good.
You just answered my question.
Any other questions?
Can I just very quick question is, what do you, I mean, it was a reference to Habermas, but you talked about the decision for aggressive democratization. I was just wondering how you interpret that.
What does he mean?
What does he mean?
What does he mean by that? No.
There is anything that you see in this?
Well, you have Habermas an analyst and still trying to understand how the idea of what the Keller tradition, so to speak, in Germany, social democracy, can be preserved at the European level, and how this European accomplishment could then be a model. This is going on, and he is in his new essay developing it further. He is trying to say, how can we be at the same time European citizens, national citizens, without giving up our identity as national citizens, nevertheless become also European citizens, as you are Greek and British, who can be a European and all sorts of things, and Catholic or whatever. Now, this is fine, and he develops out of that a couple of implications for the institutionalization of Europe, but it is, I think, very incomplete, and how to move from that state of affairs to a political step in Europe, to regain the political power, to engage in an honest effort to rewrite our, say, monetary union, or to rewrite representation in Europe. All this is unexplored. And okay, he's a philosopher and said the lawyers should do that, but it is highly, and this is why Schmidt is so strong, you see, because Habermas is in a way helpless in terms of his practical recommendations. He writes these manifestos, and people are observing how angry the old man is, but this is not an answer to the political crisis we're living in.
Saskia, so maybe this will be our last question.
Oh my God, you can already declare the last question? Then I will need to ask. I can ask more.
Yeah.
We can also just try to
Yeah. But I'll just start.
As an outsider to the European Union, even though I'm Dutch, but you know what I mean, the European often looks as two things: the format of the future a networked, complex platform with many differentiations. Okay? And it also, secondly, looks like no other part of the world could have it. You know, I don't see it happening in any other part of the world. I don't know what you think about that. Now, furthermore, and my specific question, when I do a lot of work on immigration, the international courts in Europe are really a very powerful and significant presence vis-a-vis immigrants, asylum seeking, detention, etc., and often have disciplined national legislatures in very interesting ways, in enlightened ways. And I'm just interested in hearing you say, first, what do you think about this? Are there other such boards? And thirdly, but these are very short answers, you don't have to give long answers. And thirdly, is there a curve? Are these courts that I am praising right now, are they in a decline phase? What's happening with these courts? Because there is so much instability right now in the European project.
No, I cannot claim to be an expert on this, but the really, I would not say mysterious, one can explain this, how a transformation of our mindset, which is inspired by the perception we are in a crisis that we must do something. And the recipes we learn from, say, the German government are the Sparmaßnahmen, right? Austerity is the answer to these problems. And how this infiltrates, I have cited deliberately this little opinion by the Advocate General. Now, I bet what you see at the national level already is a new hostility towards a stranger. Now, first of all, I would say, fortunately enough, we have also learned that societies, complex societies, don't change with a big bang from one direction or the other. It's more subtle, but one has to be really careful. And so many things have been done in Europe. I have mentioned my darling institution for mythology. Everybody laughs, but I love it still. And of course, a growing interaction between courts. Even the European Court of Justice will have to learn that they are not alone, that supremacy is just a myth, that they will have to learn to live with the European Court of Human Rights, that the German Constitutional Court is not as silly as they somehow look. But they have something to say and they interact, and this develops, and so many other things. So all this should be preserved. Europe is still a project, but it is at the same time, I'm afraid, also infiltrating seemingly unaffected fields of European policymaking, and I'm afraid migration problems will be one of them. And I cannot now but the courts also, well, how the courts will react, we'll see. They usually comply with it. Good. I shall say.
Thank you very much.
Yeah.